Well, good afternoon, everybody. Glad to see you all here. Welcome to the third Federalist Society event of this year. Today, we are very honored to have John Coffey from the Seventh Circuit Court of Appeals speaking on the role of the judge. We've had quite a few people come to speak to us on the role of the judge since I've been in law school, but I think this is a special treat because I look down across Judge Coffey's resume and he has over 50 years of experience on just about every level of court you could possibly imagine. I look down through here and I think the only two courts he has not served on are probably the U.S. District Court and the U.S. Supreme Court. Judge Coffey first took the bench in 1954 when he was elected to the civil court judge of Milwaukee County. He served on numerous state courts in the state of Wisconsin, including the Wisconsin Supreme Court, until he was appointed to the United States Court of Appeals for the Seventh Circuit in 1982. So, without further ado, Judge John Coffey.
Good afternoon, everybody. This is the first time I've gone out to give a speech where they had to pay you to come, give you pizzas. That's pretty nice. I'm going to have to bring that back home. Also, I hope you will forgive me for my informal gown. My good wife, Marion, sitting over here, had laid out my jacket, was packing it and everything else. And I said, no, let's leave it hanging tonight on the back of the chair, then it won't be so pressed. My professional packer didn't see it hanging on the chair. So I came with a tie and a shirt. So I hope you'll accept me as I am. The role of a federal judge is to interpret the law accurately and consistently. Based upon my experience over the years in the courts, I have not always seen that done, but I believe very firmly in it. You ask, how did I come to this reasoning, and what did I follow? I came from a family of 10 children. 10 of us got college degrees. 7 of us got postgrad degrees. From an Irish family from the Midwest. I went to Marquette University High School and Marquette University. I served in the U.S. Navy. Came out and entered law school in 1946, just after World War II. And at that time, we went to school all year round. We had 2 weeks off in between each semester. Out of our class came 24 judges that served all over the United States. When we were in law school, we went to school only in the AM hours, and the majority of us went out in the afternoon to earn our way. I happened to sell outdoor advertising. While I was in law school, I became active and went to the dean and said, Dean, first thing I said to him, why don't we have our own alumni association? He said, why? I said, you'll raise more money for the law school, and we'll have a lot better alumni to go to once we get out. I said, you can't forget, Dean, when we get through school, we have no tools. We have theory. We need tools and theory as well. He said, go to the university president. Went to the university president, and he thought it was a fine idea, and we went ahead. Next thing was, I said, Dean, about 6 weeks later, why don't we have law clerkships? Well, where did you get that idea from? Well, I said, Dean, it just so happens that they have it in dentistry, they have it in business, they have it in journalism, they have it in engineering, they have it in medicine. Why can't we have it in law? This was 50 years ago. He said, well, what law school has it? I said, let's us be first. He said, go to the president and talk to him. I went to the president. He thought it was a fine idea. He said, go ahead. Go back to the dean. Well, who are you going to select, Mr. Coffey, to head the program? I said, Dean, that responsibility falls on you. All that I can tell you is you've got 30 judges in Milwaukee County. Everyone's a Marquette grad. Your federal judge is a Marquette grad. Your U.S. attorney is a Marquette grad. Your city attorney, your district attorney. There's no reason why they won't cooperate with this alumni. It fell on deaf ears. I then went to the Milwaukee City Attorney's Office and began as a prosecutor and was in court 2 days after I was appointed. Had someone with me for the first week. Then I was on my own. Mind you, without experience, but tools. Going up against some very good lawyers. And I was told when I was hired that there was problems in the city in crime and in influence. My hirer said to me, the city attorney, if you fall on your face, you're out. I'll ask you to resign. If you go ahead and don't embarrass me, you've got it made. You will go a long ways. I began by taking 20 appeals, something which had not been taken from cases at that time for operating an auto while under the influence. I was successful in 20 appeals, all before juries. I loved the opportunity, but it wasn't without trial and tribulation. One of them was the most influential industrialist in the city who had beaten the rap 4 times. And on this particular occasion, he had injured 4 young children standing on the sidewalk while under the influence. He took no urinalysis. The captain came to me and said, Your Honor, can we go ahead? And I looked at the report. I said, yes. We went ahead. He was convicted again with an out-of-town jury, and after the trial was over, the man came up to me and shook my hand and said, congratulations. If you go any higher or want to go higher, you've got my support. You're the first one who's done it. I tell you that because when you go into the law, live up to your ethics. It's all that we as lawyers have. For your whole lifetime, the truth in the long run will get you ahead. Believe me when I tell you that. When you see what's going on in this country for the last 10 to 15 years, you'll understand and realize what I'm saying. And it isn't something that's always easy to do. But stand forward, live up to your oath, and you'll have no problem. You will be satisfied, you will be proud, and your community will be well served. Next, I'm going to talk to you something about the Patriot Act, because I know all of you know something about that and would be interested in hearing something about it. And if there's anything that you don't agree with later, please tell me. There are 16 provisions in the Patriot Act that are set to expire in 2005. But as you know, they've been approved by the House and the Senate, but different versions of each. And they are now trying to work them out before they are sent to the president. Whether they will come out in the same shape that they're in at this time will only tell. Section 203 authorizes law enforcement and intelligence agencies to share vital information, which to me is a very key part of that act. It permits the law enforcement agency to share grand jury information, electronic, wire, and defense and national security. Sharing the information under the Act assisted the government in obtaining the indictment of the alleged Palestinian Islamic Jihad. It permits foreign intelligence obtained through criminal investigations to be shared with the federal law officers. And I have been subject to this and was, should I say, happy that it was an act. Why the government ever enacted that act, I don't know. You in all probability read about last March about a judge's wife, a judge's husband, and mother being killed in Chicago. I sat on the appellate court and heard that case. The same individual who shot and killed those individuals came up to Milwaukee, where I am. It began with a simple malpractice suit against the university, against Northwestern University Hospital. The individual was a Polish immigrant, came over from Poland and had cancer. The cancer in the jaw was completely solved, but his face was disfigured. It became a psychotic problem for him. He sued and sued and sued on 3 different occasions. And on the last time when it came up, we on the appellate court reversed the trial court who said that he didn't have a case. Our court held that he did. It went back to the trial court. And the trial court had not even as yet heard the case. But this man did not realize that. When he did find out about it was when he took off after the 3 of us. The individual, thank goodness, when he was in Milwaukee, when he knew that the police were moving in on him, killed himself. But that information was shared by each one of the federal agencies and local law enforcement. Up until that time, they would not have been allowed to share all the information, meaning the FBI, meaning the DEA, and meaning the U.S. Marshals. All 3 of them worked together on that. When we went out of town on our vacation in March, thank goodness we were out of town at the time that he came to Milwaukee. Our family was escorted to Chicago right onto the airplane, and thank goodness his event happened while we were out of town. There is no reason on God's green earth why separate agencies in this country for the past 10 years have not been allowed to share information. As Senator Biden said, and he hasn't always been a backer of the present president in office, the FBI could get a wiretap to investigate the mafia, he said, but they could not get one to investigate terrorists. To put it bluntly, that was crazy. What is good for the mob is good for terrorists. This section also includes procedures, though, that the government has to specify the target and location of the activity they're investigating if they know its particular location. And they have to establish probable cause before a judge to believe that the target is a foreign power or is an agent of a foreign power. The law also allows the enforcement greater latitude when dealing with high-tech threats and computer knowledge, espionage. Law enforcement is given the ability to obtain a warrant in any district where terrorist-related activity occurs, not just the district where the initial search is conducted, but also to monitor other terrorist-related groups throughout the nation. These techniques were used to discover the Wall Street Journal killer, Daniel Pearl. Underlying constitutionality of those provisions, challenged before the U.S. Supreme Court, is the Foreign Intelligence Surveillance Court. The Patriot Act goes on in Section 3 to say, or to be classified as the most controversial, as it gives the government the ability to procure the production of tangible things, which also means a record of library books. Now, why did they want this? They have gone on to say, we're not interested in anybody's reading of books for knowledge. But the example is right back in my home state of Wisconsin. In the early 60s, a young activist, today he would have been called a terrorist, did not like what the United States was doing and bombed the lab at the University of Wisconsin, a $12 million building, and killed 2 people. Checking into it later, this man had been withdrawing books for some time on how to make the bomb. Had they had that information or had they had any knowledge of it, in all probability, that crime would have been solved before it took place. The government is not snooping on medical records or the history of any individual and every individual. They haven't got the time, now they haven't got the funds to do it. In fact, the funds are so tight that they have cut back on a lot of the security in federal courthouses throughout the country, even though these individuals are out there. The Terrorism Act, as I say, has done a lot for this country, and I believe it will be approved when it comes up for the final vote. Now I want to talk a little bit about judicial appointments. An effective and efficient judiciary is required for the American people. Judges must be committed to strictly interpreting the Constitution and the laws. President Bush reiterated this view in the past few weeks on the nomination of Harriet Miers. And if I were to guess, I would say he chose Ms. Miers also because she has no track record. Why? Because of what happened to Bob Bork and other people who have come up. I can remember a law clerk that I had a few years ago, came from your school here, undergrad, but then went on to the Georgetown Law School. He applied for a clerkship with me. His name was Paul Jocklick. He served me well for the 2-year time that he had, but he was the right-hand man of Senator Hatch. I had never met the young man before, and I have never met Senator Hatch to this day. I just saw the young man's credentials, called him in for an interview, and hired him because I was impressed with his grades, his LSAT scores, and in his interview. We have to make it clear to our senators and elected officials. The key issue today, whether anybody believes it or not, the issue is how does that person feel about the abortion issue? You can cut it any way you want. Go back to the time that I ran years ago in the Wisconsin Supreme Court and traveled the state with my good wife for a year, from one end of the state to the other. Whenever you'd get in on a news interview or a radio or television, they try to get you to answer specific issues. And you can't do it, nor can any judge. As Judge Ginsburg said on the Supreme Court, and as she properly refused to, when she was called up for her hearing about 8 years ago, she refused to answer any of the questions. You decide the case on the facts that are before you and the law as it is presently. I have never belonged to any political party, have never attended a political meeting. I'm independent and have been throughout. If someone asks me my opinion individually on something, I wouldn't hesitate to tell them what I thought individually, But as I rendered my decisions, you will see, and if you'll take the time to look at them, where I'm coming from. I will tell you in 2 cases within the last year, if you like to read dissents, you can read some long ones. I wrote 2 of them. One was in a Social Security case, where a very well-known judge on the 7th Circuit with me, probably the best known, wrote a decision and cast aside all objective evidence. And on the other hand, accepted subjective evidence from the patient and the patient's doctor alone. On the other side were 12 medical specialists, and each one of them classified her not as being entitled to Social Security benefits. In another decision, I dissented in a case involving a Milwaukee police officer who was alleged to have assaulted a young child while conveying him from the place of the arrest to the police station. What did they convict him on? They convicted him because he had blood on his shirt. And he said, "This officer hit me." At the scene of the event, there were 8 officers. Not one of them saw him attack him. Not one. He was conveyed to the police station in cuffs. He was interviewed. It came out that he was under psychotic medication and had been for the past 6 weeks. Not only under psychotic medication, but he believed that people were assaulting him and that he was going to get even with them. He did not have a bruise on his face, and he alleged that the officer had hit him in the mouth. Not a bruise. That case, my dissent is about 54 pages. In each instance, I took the testimony, the evidence that was presented, and analyzed it, and used the doctor's evidence in the other case, just to show you, and just to show the general public or anybody that reads it, that you have to have the courage of your convictions when you believe something is wrong and stand up for it. I'm not saying that my dissent is alone. 3 other judges joined me on one on the police officer case, and 4 joined me on the other. One was a 6-5 denial of a dissent, of a en banc in hearing, and the other was a 7-3 denial. In life and on the bench, today there is too much of a trend to do what the public wants or what the philosophical idea is of the date, particular date when this goes on. I can remember when I was on the Supreme Court and I was asked to get off the court to run for the U.S. Senate. It was at the time that Russ Feingold was running. And I was promised enough money to challenge him, to give him a hell of a fight. But I said no. I said I love what I'm doing. And you people would not want me 6 years from now. I would vote my conscience, not what you tell me I have to vote. And I can't do that. We need that today. We need it from lawyers above all. You are the future leaders of this country. Believe me. And if you won't do it, it's on your shoulders. You can't just stand aside and follow the crowd. That's not good enough. Believe me when I tell you that. I say to you also that in the field of judicial appointments, the current attacks on the judiciary today are something that's going to destroy it unless you people will stand up, if you believe in the decision, and speak for the judiciary. We are the only independent source of what the truth is. And that's how important it is to live up to it and do what you believe is right. We're not here to influence anybody, but to give justice. I thank you all for the opportunity of being here. I'll be free to answer anything that any one of you asks if I feel competent. And after my years on the bench, I think I have some answers. All right?
Any questions?
Yes, sir.
How should we, as members of the body politic, go about evaluating judicial nominees for whether or not they're going to behave on the bench as you suggest they ought, when we can't and shouldn't, I agree completely with you, ask them for how they would rule in specific cases?
I think you have to go to the community where that man lives, and obviously if you're voting for him, you'll be there. Do some networking with people who you believe and you trust, and ask them pertinent questions. And if the answers aren't what you think, or they're just shielding something, dig deeper. Talk to people who you feel or you know will give you both sides of the issue. You certainly won't get it from the American press. That's another thing that I think has caused a lot of our problems. I wrote about, probably 10 or 20 years ago with Judge Posner. And I'm sorry it wasn't in an opinion, it was only in an order. With every right comes a corresponding obligation. The press has the right to report anything, any way they want. But at the same time, they have a corresponding obligation to tell the truth. Now, let's talk about that a minute. That doesn't mean shielding it, or it doesn't mean not printing it. It means telling the truth and save the editorializing for the editorial page, or give both sides of the issue on the same page and not print the issue that you want to convey from the press on page 1 and put the answer back on page 13 or 23. And today you have the opportunity to do things like that we didn't have years ago, because you have the internet, you have the bloggers out there. And if you want to know, as important as it is when you're electing judges and legislators, take the time to look it up. Have class discussions on it, and you'll get everybody's idea. As I said before, you people can't realize how important you are to this nation and the welfare of it. You have an obligation greater than the doctor, the engineer, or anybody, believe me, because you have the tools to work with, to logically analyze what is said. Yes, sir.
You spoke of the need of an independent judiciary, but how do you think that relates, particularly at the state level, where most state judicial appointments or positions are elected positions as opposed to lifetime appointments?
I ran for it 10 times and won 10 times. I went across the state of Wisconsin with my wife, as I told you, from top to bottom. I ran against a man who was designated by the governor to be the appointee to succeed another judge. And I'll tell you what else I did. I went to the newspaper, not of choice, but I was called 3 days before the election by the editor of the paper, the Milwaukee Journal, and said, you're the first candidate for a statewide office that hasn't come in for our endorsement to talk to us. Well, I said that I don't know that, but it's by design. He said, why? I said, I know you're not going to endorse me. He said, how do you know that? I said, the editorial is written. I happen to know it. He said, well, what if I have a reporter who has covered you over the years to be at the editorial conference? I said, fine. I went up, I answered the questions that they had. One of the questions was the abortion issue. The other one was school integration. I answered that correctly, but they didn't think I answered the other. And when I got through with it, I said to him, I did not come here today of choice. You probably know that. One of your executives, I never told him who, asked me to come down here and said thus and so, just what I have told you. But I said, I'm going to run tomorrow, and I'm going to win. And when it's over with, don't say that there shouldn't be elected judges, because this is just how the system is set to operate. This is what they're talking about, and they say that why should 5 men on the United States Supreme Court legislate laws that you can't get through the legislature? That is the democratic process. In other words, the obligation of each judge, whether it be on the lowest court or the United States Supreme Court. Don't go to international law to try to find something that isn't any place in the law in this country. A problem of first impression, yes, dig deeply, go wherever you want. But don't go to like a country like Iran or other countries over there whose penalties for adultery or for theft. For theft, it is cutting off the hand. For armed robbery, it's the right hand and the left foot, or the left foot and the right arm. Why compare us to countries like that, or judges who are not elected and aren't independent, but are tools of a foreign government which is probably an anarchy and is not a democratic government? You're living in a democracy, and do everything that you can to continue it. Yes?
This came up recently in the Roberts
Sure.
information. How do you feel about the balance between, a lot of times before judges are in the position to run for judgeships, they're lawyers or even at the initial stages of their judgeship, in terms of how do you separate a person advocating for their client and what they actually believe? And should we go back and pull up things that people have written and personally hold them accountable for those opinions, or assume that they were advocating for someone else or just for being a good lawyer?
Well, let's say this. I think in the case of John Roberts, I believe that they did a thorough investigation of him. When you are advocating for a client, it's your duty to do everything ethically in your power, if you agree with it, to further that cause. On the other hand, if you have a problem and you can't agree with it, say, I'm sorry, I can't do that. Giving an example, and go back to my time as a prosecutor. Young man was a city employee, was charged with molesting a child. He was a painter, and he was a top union official. And Milwaukee's a big union city. And my boss called me on the phone and said, so-and-so wants you to look the other way on that, or he'd like to talk to you about it. And I said, what's your feeling? Well, he said, I got to hear what you got to say. I said, what I've got to say is, if you tell me that I'm going to do it, please accept my resignation. Because this man was a 2 or 3 time loser. And I'm not going to advocate something that I don't believe in. On the other hand, as I say, it's something that you believe in, and you think it's right, you do it, and do it to the best of your ability. And when John Roberts wrote so-and-so for the government, I would have to assume that he believed in it. Now, that doesn't mean that he's right or he's wrong, but I also believe that the government, or you and they're your client. There's a client privilege there too, which should be respected, and that should be fought to the end. Because if you don't have the confidence of your client, and their client doesn't have confidence in you, you can't defend them. It's like going into a doctor and he wants your symptoms and you only tell him half of them. You've got to tell him the whole thing, because if, on the other hand, going into a courtroom and something pops up that you've never heard before, your hands are tied behind your back. But I do think the privilege should be respected, and you as a lawyer should fight to the end to see that it is respected. Yes, ma'am.
In discussing the issue of Harriet Meyer's nomination,
Pardon me, I can't hear you.
I'm sorry. In
Yeah.
discussing the issue of Harriet Meyer's nomination,
Yes.
It sounds as though there's two camps objecting to her nomination. One because of the cronyism aspects, but also a lot of conservative bloggers and even Robert Bork object to Ms. Myers because her lack of track record indicates that she may not be conservative enough to be a nominee by President Bush. How do you feel about that second camp? Do you feel like the president has the ability to nominate somebody who would represent a conservative judiciary?
Pardon me, I didn't hear your last sentence.
I'm sorry. Do you feel that the President Bush has the ability as a conservative president to nominate somebody who would represent a conservative judiciary?
I believe the president, according to the Constitution, has the right to nominate who he pleases and who he believes will fulfill what he determines in his mind is the best person for the office. The idea about her not having been a judge before, now this is not what you asked, I realize, to me is hogwash. We have as many judges on the Seventh Circuit Court of Appeals as we do judges. We have an equal balance, and it's good for the court. Bill Rehnquist wasn't a judge before, and there are a number of other ones who aren't. Now, you're talking about because she's conservative, you don't think he's going to appoint another Ginsburg, do you?
No.
Or another Breyer?
I'm sorry, I should clarify. This actually seems to be an objection of conservative bloggers, like Ann Coulter, and Robert Bork has also mentioned this in interviews, that they don't feel that she would represent a conservative framework enough, and therefore are objecting.
The unfair thing about the attacks on her by the conservatives or the liberals, as you would call them, she hasn't spoken a word under oath. And you tell me why you should attack someone until they have a chance to answer. Not saying that when she does go under oath, they should ask her anything that they want other than a specific issue like abortion, or how do you feel about discrimination, or this or that, a certain issue on. Because you can't bind yourself to that, because you don't know what the facts of the case are that are going to be presented to you a month from now, 6 months, or a year, or 5 years from now. And that you shouldn't be asked that. But do they do it? Yes, they want to aggravate people. All right? I'm not tired, don't worry. Go ahead.
Having gone through both election and appointment, which do you feel creates the most independent judiciary in our system?
I would feel, I'm for both of them. I'm for both of them. Certainly a federal judge like myself has no fear unless you don't act, in good faith or something like that. I can't tell you what the exact expression is. And I had no problem. And I would say in Wisconsin and in the majority of communities, once you're on the bench, unless you are a finagler and deal beneath the table, You'll be in office as long as you want or that term is. The people want consistency. On the other hand, I do realize there are tough issues in Wisconsin right now, as I go back to it, are using this recall movement every so often, not to get judges, but to get people in other appointive offices. But that wouldn't be beyond them to try to get out a judge, I'm sure. But I say again, live up to what you believe in and your oath and do what you think is right, and in the end, you're going to prevail. I will tell you, when I saw William French Smith, who was the Attorney General under President Reagan, he said, Judge, when we see the enemies that you have in Wisconsin, we know we got the right man. You want me to tell you a little side story about President Reagan that probably you have never heard? President Reagan, when he was, before he was a president, was the governor of California. We had a black judge on the district court in Chicago. The judge was appointed in 1960 or 62. And on this given afternoon, President Kennedy called him at home and said, Jim, his name was Jim Parsons. Jim, I want to appoint you to the district court in the Northern District of Illinois. Will you take it? He says, well, Mr. President, I don't know that I will. And he said, why? He said, I'm getting paid more here than you're paying your federal district judges. He said, give me some time to think it over. President Reagan said to him on the phone, rather, John Kennedy said to him on the phone, I've got the head of the NAACP here. He'd like to talk to you. So-and-so from the Black Lawyers Association, so-and-so from this association. Jim Parsons said, no, I'll tell you next Tuesday or Wednesday. Called him up and said yes. And 2 years later, he's on the federal district bench, and the Boy Scout convention is held in California. When you have the Boy Scout convention, the governor hosts in that state the young people. Jim Parsons is going through the line with the young people from Chicago, and he meets Governor Reagan. Governor Reagan says to him, Jim, how are you? Fine. You've been in scouting, haven't you? Yeah. For how long? 25 years. Did you pass all of your qualifying all of your qualifying tests? Well, he said, yes, I think I did. The president asked him, cooking, hiking, swimming? And with this, Jim Parsons looks at him and says, are you the one who saved my life? He said, yes, I am, Jim. They threw their arms around each other. And then when Jim went senior during President Reagan's term, the president took his letter of resignation and retirement and wrote on the bottom of it, Jack Kennedy had the swimming pool taken out of the White House. But when I leave here, or before I leave, if you ever want to pass that swimming lesson, here's my address in California. I'd love to have you come any day and I'll certify you. That's a story that Jim Parsons told me as we ate lunch privately and said, this story has never been told, but it's a true one. Can I ask anybody else? And Jim Parsons was a hell of a guy, believe me. Yes, ma'am.
Sorry to ask another one.
That's all right, if you got two.
I was interested in your discussion on the use of international law in
Yes.
Supreme Court decisions.
Sure.
I've heard a lot of objection to Justice Kennedy's using international law in the Lawrence versus Texas decision, but I was wondering, your objection seems to be on the basis of that these come from governments that are not very similar to ours, not
Yes.
democracies.
Right.
But Justice Kennedy used European law as
Right.
one of what he's drawing on.
Right.
Do you feel like that objection is less, I guess, less there when it's a similar country to ours, or do you still have an objection on the basis of using international law at all?
Is it from I'm taking the side of Scalia and Bill Rehnquist and 3 other judges who have talked about it publicly, but not in that decision. Our basis is a democratic government. And you have got here 5 people, the only country, the only way that they can decide or write a law without the general population giving you a consensus of it in this country, the leading democracy in the world. That's the objection that I have to it. Did I answer your question?
So, thank you.
Anybody else? Well, thank you all for the opportunity. I've enjoyed being with you, and I wish you all the best of success in our chosen profession. Good luck to you. Thank you.